Where's Jim?
He's running a few minutes late.
Oh.
He'll be here.
Jim
Well,
is
he
late.
has a lot of nerve being late. 40-year Jim.
I had hip surgery 2 weeks ago and I made it on time. Come on.
You did?
Good evening, ladies and gentlemen. On behalf of the Village of Cary and the Board of Zoning, Planning, and Appeals, I'd like to hereby call this meeting to order on this Thursday, March the 13th, 2025. The time is approximately 6:04 p.m.
Okay.
We have a quorum of members, and at this time, I'd like to ask our Director of Community Development, Mr. Brian Simmons, to please call the roll.
Cassiter. Here. Graziano. Kretschmer.
Here.
O'Laughlin.
Here.
Trandell.
Here.
Williams. Here. Corey.
Here. Thank you very much. Ladies and gentlemen, we invite you to rise with us for the Pledge of Allegiance to the flag. Thanks very much, everyone. So, folks, we have a pretty straightforward meeting agenda tonight. It's twofold. One is that we have a plat of subdivision approval that Mr. Simmons will go over. And then at the conclusion of that, Mr. Euler, to my right, to your left, is going to give the ZPA a little bit of an education and training that we've committed to in the village for about an hour. So you're welcome to stay for that, and I'll leave that to your discretion. But before we get to that, we have our meeting minutes from January the 9th, 2025, and unless anyone has any objection to those meeting minutes, the chair, via voice vote, will ask for approval. So those in favor of approving the meeting minutes dated January the 9th, 2025, please say aye.
Aye.
Any opposed? Thank you very much. The meeting minutes are approved. At this time, I will now call village case number 25 ZPA 03001. This is approval for a final plat of subdivision, and over to you, Mr. Simmons.
Thank you, Mr. Chairman. As mentioned, this is a request for a final plat of subdivision related to the Ridgefield Park subdivision that was approved by the village board last summer. Just a brief overview of the property. The property was rezoned as part of the proposed development. It was annexed in the village of Cary back in 1984 and has gone through some zoning changes during that time period with the change to zoning to Business Park District in 1997. Was then subdivided as part of the William Caper subdivision in 2003. And then the subject lot was again subdivided to create the Goddard School and the vacant parcel in 2007. And then in 2019, as part of our updates to our zoning ordinances and zoning map, the village initiated rezoning of the property to the B3 Fringe Business District as we eliminated the BP district that was originally zoned. And then most recently in 2024, the petitioner submitted a plan for review by the village for the Ridgefield Park Plan Unit development. As part of the approvals granted for the project, it included a comprehensive plan amendment to change the zoning designation or the land use designation for the property from industrial employment to multifamily residential. It was also rezoned to the R3 multifamily residential district for the PUD, which will comprise a 38-unit residential development consisting of duplex and triplex buildings. The matter before the board this evening is more kind of a housekeeping item related to that project. This would be to approve the final plat of subdivision, which will create the individual lots of record for the development and the necessary easements as well to serve the future development, which is currently in for permits within the village and likely to be constructed this year. The plat has been reviewed by staff and is compliant with our standards or regulations. There were two comments that I had on the plat as far as changes that would need to be made before it is recorded, very minor items. One, that Reuben Lane was misspelled. Just needs to add an extra E to that. And then also as sheet 1, as indicated in this slide, was numbered as sheet 1 of 1 as opposed to sheet 1 of 2. So very minor changes as far as what is submitted, but staff is recommending approval of the proposed plat as presented. The developers here can provide additional commentary as well if there are any questions for the developers. Happy to answer any questions the board may have.
Thank you, Mr. Simmons. Ladies and gentlemen, questions for Mr. Simmons?
So Brian, it's been a while, it's been a while since we dealt with this since last summer. And I know we had a lot of comments that last summer. Has all those, and I can't remember them all, that's why I'm saying it's been a long time. Have we, we've addressed everything that was addressed last
Yes.
summer?
Yeah, all the conditions of approval that were included by the board were included in the ordinance for the project.
Okay.
So that's under review for the permit stage would be compliant for the development to comply with those standards.
Okay, cool, thank you.
Any other questions from the ZPA? So, sir, if you'd like to offer any additional comments, I know this is a very straightforward standard request, but if there's any other comments that you'd like to offer, you're welcome to do so. And I would kindly ask that if you want to make a comment, just approach the podium, state your name, address for the record. For those of you that are unaware, we do record this, so those that can't attend can see it in the future.
Thank you. Jay Dula, 903 Lakewood Drive in Barrington, the managing partner of Ridgefield Homes. I don't really have a lot to add to what Brian has indicated. Obviously, we went through all the architecture, landscape plans, all that was kind of worked through over the course of the approval process that we went through with the townhome approval. We have applied for a sign permit that we've been issued. We want to get a billboard up. Our sign guy was supposed to put it in a couple weeks ago. He had the frost to blame, but now that that's not a blame anymore, we hope to get that up here shortly. We're, as Brian indicated, we have all final engineering completed, and we're out for bid with some of the land development subcontractors, trying to pull all that together and finish up some of the other housekeeping items that we have with the village, posting bonds, et cetera. But we'd like to be developing out there this year, and we've had, as you know, we're building Ridgefield Landing on 2nd Street and 14. The first building has been completed, the first 2 units, they both now are sold. One's closed, the second one closed in a couple weeks. We're finishing out the remaining insides of the other 3 units, and shortly we'll pull a permit for the second building. But there's, that's a different type of product with the 3 stories, with a lot of stairs, not really geared to a big part of the market that this is geared for, with our, primary bedrooms on the first floor. We do have a mix of primary bedrooms on the second floor as well, but we predominantly, based on what we're seeing in interest as we start marketing this from that location, we are getting a lot of inquiries for what we thought would be the market. And just with respect to the final plat, as Brian indicated, those are individual lots. The townhome buildings get built inside each individual lot that's there. Then legal description-wise, we convey that once the foundation and the party wall is established, we convey that portion of it out, fee simple ownership to each individual homeowner. So it's not a condominium, it stays as a townhome. You own your own building, and all the other area around those buildings is one giant lot that's owned and maintained by the homeowners association.
Thank you, Mr. Dula.
Okay.
Before you adjourn, sir, I just want to double check with any of the members of the ZPA that may have questions for Mr. Dula. Okay, well, thank you.
Thank you.
So, folks, I know a few of you are assembled here as the public. This is the time during the application process that if anybody would like to speak about this particular application, you're welcome to do so. About this particular plat? Yes, sir. Sir, if I can ask a favor, if you can just approach the microphone and state your name and address and ask your question so we can record it. Thank you very much.
Chris Reiki, 446 Lloyd Street. My question would be, how can you change different properties? Like, for instance, this property here is at residential or industrial, and then change it so you can build houses on it. Or, for instance, how I realize this hasn't been discussed yet. For instance, the Maplewood project, that's set to be residential. It wouldn't be changed to build a new bus garage or a bus transportation area. But then, in due time, depending on what happens, which hopefully it doesn't get built, how can that get changed to a different zoning to where they can build a 5-story building with the 3-story condos or townhomes? How can that, I mean, if it gets changed, do you have, any of you have any say-so in it, or is it just whatever the mayor and the trustees want?
So, Mr. Ricci, I'll try to explain this as best I could, and I probably didn't do a great job when we opened up because I didn't anticipate this type of question. But typically, the public comment is for yourself or anyone else that wants to comment on an application. So you're talking about an application that's not really before this committee tonight. You're talking about Maplewood generically, and I think what you're trying to do, sir, is ask the committee what it does. So I'll try to, we don't normally respond back to public comment, but I'll make a point of doing it just so that we can try to be collegial. The committee here, their role and responsibility is around land use. That's the overarching goal of the committee. And when we deviate from our unified development ordinances, someone will come in seeking relief. Maybe they need a map amendment, or maybe they need a conditional use permit, or maybe they need a text amendment, or maybe there's some other relief that they're seeking, like a variance. So this committee that's assembled here does that work. The application related to Maplewood, the most recent one that we have was for the bus transportation, but I think if you were here earlier, like a couple of us were, that's going to be over near where the Aldi is going.
Yes.
So
I realize
that property, as you know, is labeled residential. That's literally what it's labeled. But I don't want to go too far into that application because it's not before this committee. What is before the committee tonight is a,
Plat of subdivision.
Yes, I
Right.
I understand that.
yeah. So that's really what's the issue is. But, you know, to be collegial here, if you want to comment further, Mr. Simmons, or anyone else for that matter, but we typically, during the public comment, allow people to comment on an application. We're not even talking about Mr. Dooler's application here. I think we're talking about something different.
But I think the easiest response to your question is we review what would be brought before us, and then we send it up to the board of trustees, and they make the final decision on what our recommendations are. So in the case that we're talking about with Maplewood, it would come before us, we would look at it, does it fit, does it follow through, do we recommend it, or do we not recommend it? That doesn't make it pass. Then it goes to the board of trustees and the mayor, and then they make the final decision, if that helps.
Okay. 'Cause I didn't understand how, like, if it comes before you, this property is zoned industrial, and like here, I don't have any problem with it, but how it can come about, because it's not gonna really, it's great that they're doing it, but like, is it something that just, like, I guess is what I'm asking is, do you have any say-so in it, or is it just a matter of what the trustees and the mayor want?
For this, again, we're kind of getting off topic as far as the plat of subdivision. Any property owner in the village can petition for a change related to their property. So if they're seeking to do addition to their home, they need a variance for that, they can submit a petition that this board is responsible for reviewing if there's relief that's required from the code. Likewise, property owners, if they are looking to develop their property, as in this case, they can petition the board for potential changes to the ordinances or the land use designation that the village has approved in the comprehensive plan for a site. So this project went through that process last summer, submitted a petition for modifying the plan. There's documentation that they provided to support the request that this board reviewed, and then they made a recommendation based on the information provided to the village board, which ultimately makes a decision whether to support or not to support that request. So any property owner can petition something, and it's up to the board to review if it's something that complies with the long-term vision of the community within the comprehensive plan to make that decision.
Okay, I was just curious, so. Okay, thank you for your time.
Thank you, Mr. Ricci. Okay, before we close the public comment portion, does anyone else want to comment on this particular application? Okay, we'll close the public comment portion of our meeting. And unless there's questions here amongst the ZPA on the plat question, the chair will entertain a motion to recommend to the Village Board of Trustees approval of the final plat of subdivision for the Ridgefield Park subdivision.
So moved.
Second.
Thank you very much, gentlemen. Mr. Simmons, would you please call the roll?
Cassiter?
Yes.
Kretschmer?
Yes.
O'Laughlin?
Yes.
Trandell?
Yes.
Williams?
Yes.
Corey?
Yes. So, Mr. Dooley, you have a formal recommendation. The way this typically works, as you're familiar with now, is that this will more than likely be placed on the consent agenda. But I would suggest you simply stay in close coordination. I know you're very familiar with our process now, and we'll wish you and your company continued success.
Thank you.
Yeah, thank you.
Good evening.
Good evening. All right, so now we're kind of into the next phase of our meeting. You might remember, everybody, when we went through our process of redoing our municipal ordinances, one of the things we discussed collectively is the idea of best practices in training and education. Holly and I had the benefit of a number of years ago going to a training together, and I thought it was particularly good. It was an all-day training, and we've had it previously with one of council, and now Mr. Euler's here to further educate us tonight. So I want to say first and foremost, Mr. Euler, thank you for taking time out of your, what I know to be a demanding schedule to be with us and to educate us, and we'll turn it over to you, and we'll see where it takes us.
This is also going to be an all-day training.
I was gonna say, Howard, you better make that, you better I know where I can make an hour last 15 minutes. So it's-
How do we want to advance? So it goes,
With your little toy.
just at the screen?
It,
we
yeah,
go.
it should pick up. Okay.
Will we get copies of these slides? Or can
We
we?
can get your copies.
Okay.
Yeah, sure.
Yeah,
And if you have any questions about what we're
yeah.
going through and you need additional information, just let me know.
Okay.
Brian know or me know. Good evening, everyone. Brian has asked us to move through some of the material, because this is not going to be an all-day seminar, that is core to your responsibilities, those most important functions that you serve as a ZPA. So I'm going to try to focus on those issues. If you have questions as we move through the material, just let me know. I may be asking you questions as well, just to tap into what you do know and what your practices are as you operate as the ZPA. So I want to lay just a foundation for what we are going to go through. We are not going to really spend a lot of time on the subdivision code. I think that's a separate process. Not that it's not important, but I'm going to focus here mostly on zoning. The zoning code that exists, the UDO that exists in the Village of Cary, creates a very basic framework for the operation of the village, for the regulation of property, for the regulation of land use here in the village. It dictates what can be done on property, where it can be done, how it can be done. If it fits those regulations, that basic template that is already in place, a property owner is essentially allowed to do what they would like to do on the property. They don't have to come see you. They don't have to visit the ZPA and share additional information here in order to receive your recommendation and the board's approval of the particular use of the land that they're proposing. Your authority to do this, I know it seems what you do is fair, should be done, necessary. Your authority to do what you do comes strictly from the Illinois General Assembly. We can't really do as a non-home rule municipality anything that we're not authorized to do by the General Assembly. So the General Assembly, if you go way back, I'm not going to go too far back in time. If you go way back in time, in 1921, the General Assembly authorized municipalities in Illinois to zone property. Believe it or not, once upon a time, you couldn't zone property. You could build on your land, whatever it was, whatever materials you had. You could use those for whatever purpose and build whatever you really wished on your property. Zoning became a very important tool to make sure that the way in which a municipality develops is planned, it's organized, it provides for compatible uses among adjoining properties, it provides for streets and sewers and utilities, all those things that a modern community needs. So the fundamental purpose of zoning then is to make sure that the community is a planned community, that this ZPA and the Board of Trustees identify what sort of a community they want to see. So let's use Evanston as an example. How many of you remember what Evanston looked like 20 years ago? If you were to walk through the downtown, what did it look like? Sure. That is a community that has been completely transformed. Now, you may hear from people in Evanston different opinions about whether or not the transformation is desirable, but their downtown is a very vibrant downtown at this point. And part of that, I think, is they have, how high are those buildings? 10 stories, 12 stories? In their downtown. That was a major transformation of their city, essentially. And they planned that. They carefully planned that. We talked, the gentleman that stepped up to the podium and asked what you do. That was years and years and years of open meetings, public hearings on how to move in that direction. And Evanston did, I believe, I live close to Evanston. I use a lot of their restaurants. I believe they did a nice job with the planning, and they have moved a good number of new residents into their community that benefit the restaurants, the businesses, so they plan for that. You've done the same here. You have planning tools that you use, that you rely on, that you make your decisions based on. So your zoning code, the property across the street that you just approved is a good example, I think, is not static. The comprehensive plan planned for that piece of land to develop as an industrial property in an industrial park. Then apparently it was rezoned to fringe business, correct? It wasn't developing as an industrial piece of property, even though that was the plan. It was rezoned to another category that it was hoped would result in its development, and now it has evolved over time to be planned for in the comprehensive plan as a residential development and has now been approved as a residential development. That wasn't, even though the question was asked, well, how did that happen? Was it magic? No, it wasn't magic. You have standards in your code, long-standing standards, that you consider as the ZPA when a property comes before you to be developed in a particular fashion. You reviewed those standards when you reviewed this particular project. The board will continue to adhere to those standards as that project goes forward. And that is how you decide ultimately whether or not a particular property should be zoned in a certain way, should be changed because it hasn't developed in the way the village has envisioned, or that the uses around it have changed over time. And that certainly has happened in the village of Cary as well, and happens in most communities. So, with the template in place, the zoning code that you currently abide by and use, it does not fit all circumstances. There is no zoning code in the state of Illinois or the United States of America that has a one-size-fits-all approach that works. How many of you have been to Mattawa? The village of Mattawa, if you know where that is. Their zoning provides for 5-acre single-family properties. I mean, they've had some changes to that zoning. They have had some disputes over whether or not that could be enforced. But they provide for 5-acre parcels. There are a lot of horse farms still in Mattawa. That's completely different than my experience. I live in Glenview. We don't have any 5-acre properties. We don't have any acre properties, I don't think, anymore. So all communities are a little bit different. We plan a little bit differently. The template that you have in place here then, and the General Assembly has provided for this as well, calls for this ZPA and the board to act at times to address those circumstances where a property doesn't fit our rules, right? So those tools, the basic tools, are a request for a variation, a request for a text amendment or a map amendment, which we've seen across the street, a request for a conditional use permit, if that's the category that a particular property falls in. And those requests come before you to take information, analyze that information, and make recommendations to the Board of Trustees about whether or not those particular requests are reasonable, satisfy the standards in our code, and then you make the recommendation you do. Thumbs up or thumbs down. So relative to zoning, I usually start out with these basic examples. This is Houston. I don't know if any of you have ever been to Houston. It's a community that's often referred to because it doesn't have a zoning code. And it's proud of the fact that it doesn't have a zoning code. You can see what happened in at least one instance when they did not have, a zoning code. This neighborhood that surrounds this tower, too, is a relatively wealthy community. They were not happy, the individuals that live around this tower. And although they all supported no zoning code before this tower went up, they were interested in a zoning code during the process that this project came before the municipal authorities in Houston. So you can get uses that are obviously incompatible. If we don't have a careful plan, and if these kinds of bodies, like this body, the ZPA, don't take their work seriously. You do take your work seriously. Village of Cary is a well-planned community. If you have driven the old Indian trails, even today, Route 12, Route 14, you will see the vestiges of no zoning code. As you see uses that are next to each other that don't seem to belong next to each other, they don't belong next to each other. There was no zoning at the time, no plan. Those uses went in and now they're still grandfathered. The uses are still grandfathered as lawful uses. So, in addition to being the zoning code authorizing zoning, you are then really tasked, this ZPA and the Board of Trustees, based on your recommendations, you're tasked with considering, as part of your core responsibilities, those instances where a property doesn't fit the rules comfortably. So you get these various requests for different kinds of relief relative to properties in town. You are, and all of you I think understand this, a joint plan commission and zoning board of appeals. What is a plan commission? Plan commission is also established by law, by the General Assembly. What's a plan commission? What does it do? Kind of you. It's what you do. It does subdivision review. It considers conditional uses and makes recommendations on those uses. It considers text amendment and map amendments. And the zoning board of appeals does what? It does one thing, or it does two things. Sorry.
Yeah.
What does the zoning board do? When you act as a zoning board, these two bodies are both created by statute. You sensibly here, and most communities have by now, combine the two bodies, and you can by law. So you serve both functions. You don't have to have two full bodies that meet once or twice a month to consider different matters. So what does the zoning board do? What's left? We
Variation.
did conditional use, yes.
Variation.
The zoning board considers variations. Now, those may, I give you this list and say, okay, there are conditional uses or map and text amendments, subdivisions, all different kinds of uses of property and regulation. A variation is a very specific kind of requested relief, and it is considered to be a fairly dramatic deviation from the requirements that we have set forth in our zoning code. So it has very specialized standards that are expected to be met before it's granted. Now, does that always happen, that we strictly adhere to those standards? If somebody's coming in for relief that doesn't appear to be particularly dramatic, nobody's objecting to it, what typically happens? It gets approved, right? Those are our neighbors. And we don't really see the harm in granting that relief, and it seems like a useful approval of relief, or at least recommendation for relief, for the property owner, for reasonable use of their property. We're going to talk about what the technical rules are, and those are probably more important when we're considering more complex or larger projects that could be impacted by a variation. So I give you a couple examples here of the failure to zone. So you are a mixed Plan Commission and Zoning Board of Appeals, Zoning, Planning, and Appeals Board. And the basic mechanism you are required to use and you do use to conduct your work is what? How do you conduct your business? You're required by law to do it this way. You have public hearings. You can't make decisions because you think they're a good idea, because you've discussed them here at the ZPA dais. You can't make decisions because you studied an issue carefully. You can't make decisions because you're an architect or a contractor and you have enormous expertise in an area. The manner in which you make your decisions is you hold a public hearing on all of these forms of relief: conditional uses, variations, text amendments, plan developments. You take information from the property owner, from the petitioner. It is their responsibility to meet the standards, to present you information as to each of the standards in the zoning code that relate to their request. You also then allow the public, has a right in a public hearing process, to also offer information related to the request, evidence, testimony, feelings, opinions that they would like to share with you, for you then to gather all that information as this board, analyze the information, discuss it among yourselves, and make a recommendation to the Board of Trustees. The Board of Trustees then ultimately makes a decision, yes or no. So you are a recommending body, but the work that gets done on these petitions, the actual information that the relief is based on or the request is based on, the board doesn't do that work. The ZPA does that work. And you're required to do that work. That's what a public hearing is. We'll get into the rules that relate to a public hearing too. I think generally you run your public hearings probably in a strictly technical, procedural format in every instance, but you've had bigger hearings, I would imagine, at some point in the past. Meyer is one that you mentioned.
Yeah, I sat out for that one. I don't know.
Right. So in those cases, when we know we have a complicated request that is going to involve a lot of information, a lot of testimony, a lot of evidence, it is more important to stick closely or more closely to the rules that apply to a public hearing process. We'll talk a little bit about that as well. So I had mentioned your zoning authority doesn't come from the fact that it's a good idea to have zoning. It comes, we only have that authority that we're granted from the Illinois General Assembly, and we have been granted general zoning authority. Home rule municipalities have more authority relative to planning and zoning and uses, regulatory authority, than a non-home rule, but you still have significant authority and important authority. These are the basic you can call them summer requirements. The Unified Development Ordinance is. It guides your procedures and decision-making or recommendations. And then there are documents that are more guidance for your decision-making and background information that are important to the focus that may exist in the planning that has been done relative to the property in the village. Those documents include the sign ordinance, the subdivision ordinance, the plan development ordinance, and then the comprehensive plan. You heard the comprehensive plan reference tonight, that it was changed as to the parcel across the street, the subdivision across the street. Why was it changed? Why was it important for us to change the comprehensive plan before we rezone that property? The comp plan is our long-term objective for the village. So if I guess we could do it backwards. It would be a backwards way to do it, however, to rezone a property and then change the comprehensive plan. So the comp plan really is a document that guides our decision-making in large part, and in this case, it was changed to reflect the plan for the property across the street, and then the property across the street was zoned consistently with the change in the comprehensive plan.
So the comp plan is more fluid.
It is.
Correct. Yeah, and generally, when we do receive a petition for rezoning, if it doesn't directly align with the comp plan, it is something that staff requests the developer to add to their petition. If it's something that would be supported, so that's usually something, whether it's not a specific request from the developer for their project, but it's something that we would request to be added to it to make sure the two documents do align. There are, in some cases, we have approved changes to zoning based on recommendations in the comp plan, but did not specifically change the land use designation for the property, just in case the project did not move forward for whatever reason, that it would revert back to its previous case. So there are a few instances where there will be a trailing village-initiated amendment to the plan to reflect the project when it actually gets constructed. So there's, an example is the Harper Point project that we discussed in January. When that was considered by the board, the land use designation was for the school that was on the property at the time, so it was a public institutional use designation. The board did approve the rezoning of the property for the residential project, but wanted to wait until that project was fully completed to then convert that comp plan back to that designation. So there are a few properties, and even the developer that was here this evening, his landing project, which is in the downtown area, it's zoned a district that would allow for, the zoning district allowed for his use that he was proposing for the townhome project, but the land use designation specifically there is for a commercial project. So as that project is completed, we would come back to the board to make a modification of the plan to reflect what actually is on the site.
So it's, let's call it best practice to follow the comp plan. It is not uncommon for a parcel to be rezoned ahead of the change in the comprehensive plan. It does happen. And the reason for that is, first of all, comp plans are changed or updated maybe every decade, 15 years. In the meantime, everything's changing. Life goes on, property gets developed, trends develop in town, and it necessitates rezonings that may not be consistent with the comp plan. Changing the comp plan is a lot of work. Changing the overall plan, even changing a portion of the comp plan is a lot of work. So, there's a downtown Cary strategic plan that relates to a certain area of town, obviously, the downtown. And then I thought it was going to be in here, the Algonquin.
I didn't have time to add it, so I apologize. There's a second focus plan that the village adopted for the Route 31 corridor. As the board will recall, it's the Cary-Algonquin sub-area plan that the Village of Cary worked in conjunction with CMAP and the Village of Algonquin that has more focused recommendations specifically for the Route 31 corridor.
So these also come into play when we're looking at even individual property development, but clearly when the Maplewood site the proposal comes to you regarding that potential development on that site, it is impacted by the prior planning that has been done for the downtown and that has been included in the comprehensive plan. and that has been included in the agreements to date with the potential developer. So I mentioned this, that these are your core, at least for tonight's discussion, we're going to talk about these core responsibilities. You have a comp plan, you have a zoning ordinance, and then you have ways for property owners to come to you to say, look, there is no one-size-fits-all formula that relates to all property. I have a request, a specific request related to the development of my property, and it may fit into any of these particular categories. They all, as to each one of these categories, there are standards in your UDO. I don't expect you to be able to recite them, but there are very specific standards that relate to each one of these forms of relief that somebody may request in the village. So I mentioned this before, Zoning Board of Appeals hears variations, and it can happen that an individual or property owner asks for an interpretation of a provision in the code. Brian makes that interpretation as the Community Development Director, the zoning administrator. There is an appeal process to you, the ZPA, in the event that somebody, heaven forbid, would disagree with the wisdom that a Brian Simmons can bring.
It's my personal favorite, yes.
It actually happened, Council.
Yeah.
First week of his job.
Is that right?
Roughly, yes. The first 6 months, yes.
Start. So those appeals, that appeal process, in order to provide for a reasonable amount of fairness in the event that one individual has made a decision that is not deemed or believed to be a just decision, it can be appealed to this body, for this body to also weigh in on that particular interpretation. There is an alternate member. I guess he used to be the alternate member. The eighth member, there are 7 members of this, of the ZPA under your code. There can be more on a plan commission, but you have 7 members. The alternate member of the ZPA is a member of the, if this makes sense, is a member of the plan commission. Okay? The statute allows for an alternate member to be added to the plan commission. So as to the underlying authority that creates the ZPA, that alternate member is essentially a plan commissioner. That person cannot, that associate member cannot vote on variations. If they slide into, if member 7 is not here one evening, that associate member can't serve in the place of the 7th member to vote on variations, but that's the only limitation.
Great.
So you're combined into one body. We've already been through this. I mentioned the core duties of the Zoning Board of Appeals and the ZPA at this point, and that is what we are going to focus on. So what is the fundamental purpose of a public hearing, as you understand it?
To hear the public's opinions.
Serves several purposes, right?
Gathering information and, well, I mean, the packet gives us everything that Brian's saying, here's what the deal is, and gives us information on what we're looking at as well as what's up for consideration.
Right, and let me suggest the biggest benefit to you who all have jobs probably, outside of the service on this body, the responsibility, this is true of a lawsuit as well, the responsibility to present information about what you're asking for is not on you. It's not on Brian, although I'm sure Brian provides information on each of these petitions. It is on the individual that's asking.
Right.
So as to each of the standards set forth in the code, the individual that stands at the podium and addresses you and their team is responsible for providing you the information you need to make a meaningful decision as to whether or not they've met the standards. Now, you can, like I said, for the less significant requests, you don't task a homeowner who's not here with an attorney with a particularly sophisticated presentation, but it is their responsibility to bring to you the information that you need to make a decision on whether the standards have been met in the code. So as to all those applications, the public hearing process is the fundamental vehicle that gets you to where you need to be able to make a recommendation. You need information, right? Okay, they have to give it to you. They have to present it. You get to ask questions. You can also ask, obviously, the village staff can present additional information that's germane. And then the public has a right, based on the fact that they live in the village of Cary, and it's usually going to be the individuals that are adjacent property owners, or at least nearby, the individual that's asking for relief. They have a right to also appear here and present information to you as well regarding the request that's being made. So if somebody's making a request to enlarge their house significantly, or to change their house into a business, a home use in a business, you may get the next door neighbors coming in and either saying, that's fine, I don't care, or I don't want this in my neighborhood. I don't think it's appropriate. I don't think it's consistent with what the zoning code does or doesn't allow, and present information as to why that would be a detriment to the adjoining property owners. They also have a right to present evidence, or whatever you want to call it, information. Again, they don't have to have an attorney to give you information. They can provide you the information in whatever form they think is reasonable. And then you decide how reliable that information is. So for text, each one of these requests that can be made to the ZPA for your recommendation has its own set of standards in the code. You hear, when Brian prepares the packet for your meeting, it has the standards for that particular request. If it were a text, zoning text or map amendment, it's going to have the standards from the code in your materials. Essentially, when you're sitting here listening to information being presented, that is what you're looking for. Am I getting information as to each one of these standards? That's a good outline, too, to ask your questions off of. But wait, you haven't said anything yet about, do you have any additional information to share about this, or this, or this standard? So these would be the most nominal of the standards to change a zoning or a provision in the zoning code. The standards are not as rigorous as you will see for, as you already know, but as we'll discuss, for conditional uses and for variations.
Can I jump in there for a second? So, if you're wondering about this part of the discussion, you can blame me, because if you go back to the January the 9th application, and it talks about plan development standards, comprehensive plan, public welfare, impact on property, impact on public facilities, that's not on us. That's on them.
Yep.
So that's the thing to remember, like, I think a lot of us, me, feel like, is that my responsibility to be educating them, or it's the other way around? So there's a whole laundry list of these items, and that's on the petitioner to explain to this committee how you reach your conclusions. And so that's the point that I was really trying to get after here, Mr. Euler, is that this bit of information that's always on our applications, it's on the petitioner. Absolutely on the petitioner.
And that's generally, when we have petitions be submitted, that's one of the items that we do request petitioners provide as part of their application, is a response to the standards. So there's usually, majority of the time we do receive that, and it's in the packet as a written response to the standards, and they either have a response to each individual standard within the packet, or we'll have a blanket response that says that they comply with those standards. But that's generally, again, if it's a resident asking for a slight variation on their property, they're not as familiar with going through this process as a larger developer might be, and don't have the ability to respond to those types of standards more. So that's where staff assists them with the completion of the application, but it's still on their part to provide the response. But that's usually a part of the documentation that's provided to the board, is their response to those standards in a written form, and then there's the ability for them to comment on that publicly here as well.
All right. So let me note that it is not me that is suggesting that the standards in the UDO have to be met. It is the UDO that specifically says, I have cited for you here from section 14.9.2.2, the language of the UDO. And the language of the UDO says, this ZPA shall recommend, if we're dealing with an amendment to the zoning, the amendment be approved or denied where the applicant has demonstrated or failed to demonstrate with evidence that the standards set out in the UDO have been met. It goes on when you move to map amendments. In determining if the standards in this subsection are met, the board shall consider whether the petitioner has met the following criteria. It's not necessary to meet them all. That's in this area, text and map amendments. When we talk about variations, the law is very specific that a petitioner for a variation is required to meet all of these standards for variation. Now, they don't have to strictly meet them, but they are expected to introduce information as to each of the standards. A variation is a different form of relief than any other form of relief. So for zoning, if we ever were to have a dispute around a zoning decision, text or map amendment, what courts look at as the most important information that you received and that you based your decision on is the existing land uses in that area near the property and the zoning that surrounds the particular property that has asked for relief. Those are far and away the two criteria that the court primarily relies on. So variations. Again, I'm not gonna spend a lot of time focusing on each one of these criteria. I'll just say each one of the criteria is important. So, your code.
I apologize, just for the being taped. Can you give an example of what a text or map amendment would be so that people who are maybe watching would understand?
Sure.
We know what it is, but.
Sure. Yes, that's a good point. A text amendment is a change in one of the textual provisions in the actual zoning code document. So if the zoning code currently doesn't provide for, let's say, a home occupation business in a particular zoning district, a property owner can appear before this commission and ask that that particular use be added as an amendment to the text of the zoning ordinance to allow for that use in a particular zoning district. A map amendment changes the zoning classification of a piece of property in the village. And the map meaning there is a zoning map in the village, an actual zoning map that we have to update every year that reflects all of the zoning classifications of properties in the village. And all property has to be zoned in some fashion. So if we look at another form of potential relief that somebody could request that the ZPA consider, a second form of relief is a request for a variation. As I mentioned, the variation is a different kind of relief that's being sought by a petitioner. It is a request to not follow the zoning code. The other requests are map and text amendments, conditional uses, plan developments, are essentially requests to follow the standards, present information, and ask the ZPA to recommend the particular development as consistent with what we want in our zoning code. A variation is the opposite. A variation is a request to relieve a property owner from the requirements, some requirement, a particular requirement of our rules that has caused a particular hardship to the property owner and is not allowing, in the estimation of the property owner, an appropriate, reasonable use of the property as anyone else is allowed to use their property. Does that make sense? All right. So there are cases that actually suggest that a variation process essentially is, and the General Assembly has allowed this kind of relief, so that we avoid somebody's contention that we have taken their property by regulation. So if they can ask for a variation and it is granted, we are no longer so limiting the use of their property by regulation that we are effectively taking it for public purposes by our regulation. A variation is granted or not granted by you acting as a zoning board of appeals member in your dual role as a plan commissioner and zoning board member. To approve a variation, there must be 4 members of the ZPA that vote yes. It is not, if one of you wasn't here this evening, you got a request for a variation, and you had or let's say two of you, you had a 3-2 vote, that is not an approval. An approval requires 4 affirmative votes of this body, the ZPA. What happens if you don't approve a request for a variation? What does that mean?
Means it's a negative recommendation to the Board of Trustees.
Right, and what's the impact of a negative recommendation on a variation to the board?
Don't they have to go supermajority then? They do.
It is a 2/3 vote of the entire board is required, meaning 5 members have to vote in favor of the Board of Trustees. So that's, yeah.
Just so on the flip side of that, if it is a yes, how many would you vote in order to pass it?
Just
Then it's a straight up and down.
Just a majority, right. So understanding that when the board acts on zoning matters, it adopts an ordinance. To adopt an ordinance, you require a vote of at least 4 positive votes from the board. That's a separate legal requirement that has nothing to do with zoning, but an ordinance requires 4 votes to be approved. So that is a brief reference to variations. There are some other things that I do want to discuss about variations. A conditional use permit is a third form of relief that somebody can ask for. What is a conditional use? A permitted use is what? What's already in our zoning code. If you are proposing to develop your property with that use and you otherwise conform with our UDO requirements, you don't have to come here. You need no other approvals other than to approach the village staff, apply for a permit, and you should be approved to develop your property. So what is a conditional use? Not exactly. Right. So conditional uses will be set forth in the code just like permitted uses are. So you've seen the tables in the code that set forth the particular zoning district, the use that we're talking about, and then as you work your way across B3, B2, R1, R2, you can see what is or is not permitted, P, and what requires a conditional use in order to be developed on the property. Those are all in the zoning code. Conditional uses are all listed in the zoning code. By being listed in the zoning code, you're not going to like this. Once it is included in our zoning code, a conditional use is not a privilege. It is a right just like a permitted use. The only difference is they have to come here and ask for it and show what the impact of that particular conditional use is going to be at their property. They have to show you that it doesn't need any other particular recommendations to address the impact that their conditional use may be causing as a condition of the approval. But once it's in the code, a conditional use is not an approval that you have discretion to grant or not grant. It is already allowed by our code. The only question is, do we need to address with conditions the special impact that this particular use may have in its area? Does that make sense? It shouldn't, because when we think of special uses, that's what this is. It doesn't seem like that should be automatic. That's why you would name it a special use, but a better term for a conditional use is a conditional permitted use, because it is a permitted use with conditions, with potential conditions. It doesn't have to be conditional. The code itself can also impose certain conditions. So when you add a conditional use to the zoning code, many times the ZPA and the board, with the special use itself, will say it's allowed in that particular district, subject to the following conditions.
Yeah, we've done that.
That have to be met up front.
We've done that several times.
So how come we don't call it special use?
It's a term that goes back and forth. So some communities do refer to special use. Cary's historically referred to as conditional use.
A lot of communities also refer to a special use as, I want to put in a carnival for the weekend. That's a special use, and not a conditional use.
We won't call that special use here, will we?
No, in our code specifically for these types of uses, it's referred to as conditional use within our code. I have worked for another organization that referred to them as special uses, so the term's interchangeable. It means the exact same thing.
So, Mr. Bueller, I know you're gonna go through each of these categories. One of the things that I find myself scratching my head about, particularly on the higher profile applications, I don't wanna put you on the spot, but you know this better than I ever would. Do you consider weighting any of these categories? Like when you're looking at this, if you're sitting in a ZPA commissioner chair, would you say that this is more important than this, or are they all equal when you're going through your evaluation? You're welcome to look at this.
They're not all equal.
Right.
So let's use, and we'll get to this, let's use traffic. Traffic is not considered to be a determinative factor in a request to use property. Is it relevant? Yes. Aesthetics are considered to be a legitimate consideration when you are taking information about a proposed development, the way it looks, whether or not it's reasonably compatible with the neighborhood. That is not considered to be a determinative fact. That alone should not be the basis for saying yes or no to a request for a particular kind of development. Same thing with traffic. However, it's relevant. So yes, there are certain criteria that are more important than others as you consider the standards. It can depend on the use. It can depend on what the property is being proposed to be developed as.
Thank you.
All right? So you'll see with this was true of the text amendment and the map amendment too, the standards that I included in the information here, that when a property owner asks for this sort of relief under the zoning code, they're essentially presenting information to you that indicates that they're not causing harm. Use will not be detrimental, will not substantially diminish or impair, will not impede. The variation was the opposite. The variation was required to show that they needed it because their property was being restricted, diminished in some fashion. So they're two sides of a coin. I mentioned this before, burden of proof is on the person who's standing here in front of you who owns the property and is asking you for a particular kind of relief as to each of the standards. If they don't get it just so, again, if it's your neighbor, if it's somebody who doesn't have a major development in front of you, can we be more flexible in the information that we require to meet the standards? Of course. That's a reasonable way to deal with requests that the ZPA has to deal with and the board has to deal with. So the burden is on the applicant to show that by a preponderance of the evidence that they should be granted the relief. What does that mean? I had to pay for this when I went to law school. 51. If you were looking at a teeter-totter, whichever way the teeter-totter leans, as soon as it leans, that's a preponderance. So as long as it is more likely than not, essentially, that the information that you're being presented is accurate, reasonable, reliable, that's enough to meet the burden. Findings of fact. What are findings of fact? This also, what I have reflected here for you, comes directly from the UDO. It also comes from the law, but it comes from the UDO. So the Board of Trustees, when it decides a matter related to a conditional use, a variation, a text or map amendment, or plan development, is called upon by law to make findings of fact as to each of these standards we've been talking about. So when the petitioner presents information to you about their requested relief, that information should line up with each of the standards. The findings of fact then are, did we receive information as to this standard, this standard, this standard, this standard? And what did it show us? The most important findings, you okay?
Oh, I had my hip replaced, so.
Sit too long.
It's a finding of fact, Frank.
It's a finding of fact, I can't sit very long.
So you don't make findings as a ZPA, but the Board of Trustees needs your findings in order for them to make findings. So you don't make final findings, but you send findings to the board in order for them to have the information they need to make appropriate decisions at their level, and to include those in their decision. The decisions of the board on these matters are to be accompanied by findings of fact, by law. What principle underlies the need to provide findings of fact? When a governmental entity acts, whether it's a school district or a village or park district, what is the limit, the ultimate limit, that renders a decision or an action by a public body to be unlawful or unconstitutional? If they act arbitrarily and capriciously. So if a public body makes a decision that affects somebody's rights in some fashion, and that would be a property owner, if you do that arbitrarily or capriciously, it's unlawful. What do findings of fact do relative to somebody's assertion that we acted arbitrarily? They contravene an assertion that it's arbitrary. It's based very carefully on information that you're setting out, that you received in a public hearing setting. You gave someone a full and fair opportunity to present whatever information they had. You carefully considered that information. You allowed the public to offer their input as well, and then you made a decision. That's the opposite of arbitrary. It is a substantiated, considered, well-founded determination. Now, it's only a recommendation. Your findings are accompanying your recommendation up to the board. But at the end of the day, that's the information that the board needs to make its findings. All right? It's true of any decision made by a public body, that those decisions are supposed to be supported by findings. In this case, you have a checklist, essentially, of standards that you are taking the information for and then lining it up with those standards as to each of these forms of relief. So I mentioned this before, and I'll just share with you that I cite 2 cases for you here. There are lots and lots and lots of cases that tell us that it is not enough for the ZPA or ultimately the Board of Trustees to say that there are practical difficulties or particular hardships with this property owner not being granted this variation. We can't simply repeat what our ordinance says without substantiating it with some kind of information that was presented. And this happens all the time. The ordinance that the board adopts just repeats the standards in the zoning code. That is not a finding of fact. That is simply a recitation of what our code requires. Same thing is necessary with a conditional use. The courts have said have to have findings of fact in order to meet the fundamental legal standards that are required for the grant of a particular request for relief. It's going to be simpler with a conditional use because there just has to be a showing that I am not having, my proposed use is not creating adverse impacts in the various ways that our standards call for. All right, so what information is potentially problematic if we include that in our decision-making? So the individual property owner comes in, presents information as to the standards in our code. You listen to those, you ask questions, the public's allowed to comment. What information takes us outside the public hearing process that is supposed to allow us to gather the information that we need? So there are legal decisions that relate to some of these bases that have been relied on. A village denying a zoning request because they knew the property owner had not paid their property taxes and that there were property maintenance liens on the property. So the board decided on information from outside the public hearing process, essentially, that the property owner should not be entitled to the relief because of other matters related to the property. Complaints by neighboring property owners regarding regular noise at the property. Now, if that relates to what the relief requested is, that they're going to increase the noise at their swimming pool in the backyard by expanding it, it's relevant. If it has nothing, if their barking dog in the backyard has nothing to do with the requested relief, this is not a relevant consideration for your decision-making or the board's decision-making. A personal belief, this happened recently, I think, with the cannabis industry. It's hard to separate or divorce strong feelings that you may have about a particular use and not make that part of your decision-making in some instances. But if a use is lawful and it's otherwise allowed, it really isn't an appropriate consideration relative to the standards that relate to a conditional use, like a cannabis dispensary, and shouldn't be the basis for a decision. And then let's use traffic again, which is a problem with every single use that you'll have come before you, retail and commercial use. A potential traffic problem is relevant if it's determined that that traffic generated from that use is going to be different from the other uses that are permitted in the same zoning district. So if we don't like a particular use that is currently before the ZPA or the board, and traffic is the reason, the generation of traffic, if it turns out that 6 other permitted uses in that same zoning district that could locate at this property and could develop at this property would generate more traffic, we can't really look at the traffic generated by this use and say you are creating a unique traffic problem that should result in the denial of your petition. They are developing consistent with what we've identified as appropriate uses on the property, including the generation of traffic. All commercial and retail developments generate traffic. And I know it comes up at every single hearing involving commercial development and retail development. It does arise. But there is a way to analyze and assess what the traffic data means. Doesn't mean we shouldn't have a traffic study or analyze that as a factor, but it needs to be considered carefully. So in the consideration of variations by this ZPA in your code, you provide that a variation can be granted from the minimum lot area requirements and the maximum density requirements, potentially. And a recommendation made on those 2 issues to the Board of Trustees for their decision-making. Your decision-making relates to any other grant or grant with conditions regarding variations, or a denial that involves fence variations, sign variations, or any other variation. So make sure we understand this. The 20% doesn't relate to fence or signs, right? So you have sole authority regarding variations for fences, sole authority regarding variations for signs. You have some authority or all other variations that do not exceed 20% change in the relevant requirements. Does that make sense? Yep. So there's no Board of Trustees in those decisions. That's just this body. I mentioned this before, I'll just reiterate it, that as to a variation, the courts view the grant of a variation a bit differently than other requests for relief from zoning, and indicate that the standards to be met for a variation require that all of the standards set forth in the code are to be met, reasonably met. You don't have to apply them strictly, but all of them have to be met in order for relief to be granted. Now, that's going to be a little bit different, again, depending on how significant the variation is and what kind of an impact would it make. I'm sure you've granted variations before where somebody hasn't technically met all the standards. The bigger the petition, the bigger the development, I think the more important it becomes for all the standards to be met. If you see the same request, this applies to fence variations, I think, in some communities. If you see the same request for a variation 15 times, it may be time for a text amendment. it may be time to say, why do we require everybody to come in here, ask us for a 6-foot fence instead of a 5-foot fence, when we grant them all? They all seem reasonable. Maybe it's time for us to include something in the code that gives people a little bit more flexibility. So that can happen.
And that's precisely what we did as part of the UDO process for a lot of variations that we had been seeing within the village for fences is one, lot coverage was another one for single-family homes. Those were repeatedly approved by the board, so we did change those regulations to reflect those that relief that was being granted, and that's this board. Some of the members that have been on the board for a longer time period have seen a decrease in those types of requests coming forward because of those code changes. But if we continue to see requests that the board will continue to approve and we get more data as far as what those variations relief have been, staff will look at, making recommendations to modify the code as well.
And you've created a relief mechanism in your code relative to those variations that you can grant at this level as well, where something doesn't have to proceed from here, also up to the Board of Trustees, if it's under that 20% level. So that's also being more flexible regarding some of the relief that individuals may request from some of the requirements of the code.
And there are some provisions as well that the village board is granted to staff to perform. So again, setback variations or whatnot, if it's within a certain provision of the code, there are some authority that staff has to grant administrative variation for a property as well.
Business friendly. We discussed this a bit before too. What is a permitted, what is a conditional use? They're the same. They're the same thing. A permitted and a conditional use is the same thing. However, conditional use can be conditioned to address the impact that more specialized use may have on the adjoining properties of the neighborhood. So there is an exception. When I said it is a conditional use. A conditional use can be denied if it actually doesn't fit the category that it was designed to fit. So every conditional use identifies a very specific kind of property development. If it happens that this proposed use is actually different than what we intended by the conditional use, then it can be denied, because what they're really asking for is a text amendment. If it's so different than the term, than the definition that Brian gives the term in the ordinance, what somebody is really seeking is a new use, not a conditional use. And on that basis, it can be denied. Or if where they are proposing to place this in the particular zoning district just doesn't fit any intended use of that conditional use, it's on a particularly busy, it just doesn't work based on what was intended by that category, that also can result in a denial of the use altogether, because it's different and unique from any of the intended purposes for including it in the code in the first place. Does that make sense? All right, we mentioned the public hearing process. There was a major battle years ago over a Meijer store in Lyle, near Lyle. Community came out to public hearings, just packed room at all the public hearings. The rules that were enforced at that hearing, the public hearing, the board appeared to be leaning in favor of the Meijer development. The individuals that showed up at the hearing were absolutely dead set against this development in that area. And the chair of their ZPA, or Planning and Zoning Commission, imposed rules at that public hearing that limited the time that individuals had to testify, the number of people that could testify, because the time for the hearing had elapsed. So it was declared that they were done with testimony. That procedure that was followed ended up in court, and the Illinois Supreme Court declared, look, you can have rules for public comment. Those rules don't apply to a public hearing. A public hearing and a public meeting are different, okay? So when we have public comment at the village board meeting, and you have it here as well, I assume, we have rules about, well, I don't remember what is it 3 minutes or 5 minutes? We have reasonable rules for the amount of time that somebody can use to share information with the board or with this board, and flexible about that. And then maybe a 30-minute period altogether for public comment. A public hearing is not the same as a public meeting. A public hearing has to allow for the introduction of evidence by the interested parties. So if 30 people show up 30 residents show up at one of your public hearings, and they want, assuming they're not just repeating one another, they want to introduce evidence about the petition that's in front of you, they have a right to do that. And they have a right to the reasonable amount of time that it takes to do that. So limiting a person at a public hearing to the public meeting rules is impermissible. Both sides have the ability to do essentially what you've seen in all those shows that are about lawyers in courtrooms. Both sides have the ability to present their information and then ask questions of the other side, tests the other side's evidence. And we have to have a process that allows enough time and the opportunity for both sides to do that.
Can we go down this path a little bit further? Because typically when I'm doing the introduction to a larger petition, I usually try to take everybody through the process. So we're saying in a public hearing, what I've tried to say to people is that like tonight when the gentleman was asking, is that it's not our job to respond back to them. That's typically not our responsibility.
Right.
So, and I've also said to them, it's not your job to ask the petitioner this, and this, and for them to respond back to it, but we ask them to catalog the questions, and then during rebuttal, they're allowed to address the comments.
Mm-hmm.
So is that the right process, or is it sounds like it's a little different what I'm hearing right now.
What he was asking this board questions about the Maplewood, yes,
Different case, yeah.
the Maplewood development or potential development. You never have to answer questions. You're never tasked with presenting information back to somebody or answering questions. You can always defer those to staff. It seems to me it's best practice to refer it to staff. Firing off an answer spontaneously when you're asked maybe a complicated question or a difficult question, this is not really the place to offer a spontaneous answer. It may be important information, and if it is important information, we're going to take the time to consider it, study it, and give somebody an informed response. If you want to answer somebody, you can. It's not required.
We typically try not to.
Right.
So, okay, thank you.
I've never seen an elected official or a plan commission or zoning board member win an argument with somebody who's upset at the podium. I don't think it ever will happen. So, go ahead.
So what we are doing here is a public meeting, right?
Yes.
So does the ZBA ever had a public hearing, or would that be a separate body? Would it be like
All of your business, when you're considering a petition related to a conditional use, a variation, a text amendment, a map amendment, a plan development, anything else, Brian?
Yeah, there's
that
a
it?
few, I didn't hear the full list, but yes, there's a few things.
Those
Yeah.
are all public hearings.
Yeah, so, yeah, when we call the case, we call the cases on the individual projects that are proposed. So if tonight we just had the one case. If there were 3 cases, there'd be 3 separate public hearings for those individual cases. And that's why when we do the minutes, they're specifically for those cases, because that's the public hearing for that project. The meeting in general of the zoning board is the public meeting. So you're kind of 2 in 1 from that standpoint.
But I want to continue down what Mr. Euler is saying, because we know the Maplewood thing's going to be here sooner or later. And when sooner or later is, I don't know. But that could be potentially a lot of the public. And it's been my experience that I've been told by staff previously that we should limit the amount of time that people have to comment on any aspect of an application. In other words, otherwise you'll be there into the early hours of the morning, because you could have hundreds of people.
Right, so you do not have to let everybody say the same thing. Everybody doesn't have to stand up and repeat the same thing. So get to that point in a meeting where individuals are simply saying what he said.
Right.
But they say it and say, well, I think we've heard that information, and we'll note that you have the same feeling. Sometimes the chair in those circumstances will say, can I have a show of hands from people who, who believe whatever it is, that you've heard it out 3 or 4 times? Can I have a show of hands so we know how many people support that same viewpoint? So you don't all have to step up and say the same thing.
What
about
the time limitation?
Well, so there are 2 ways to handle that. If somebody is, I'm not saying this would happen, I've seen this happen. I have seen property owners come to public hearings before zoning boards and plan commissions and bring an attorney. And the attorney will have his own team, an architect, an engineer, and will want to ask questions of the petitioner and the petitioner's team. I think we have to allow that to play out. That
Part of the process.
the reasonable questions that the attorney has or the information that they want to present through their team, I think we have to allow that to happen. For people in the audience, again, who are repeating a lot of people in the audience are going to be saying the same thing. So that doesn't have to go on indefinitely, and say, we have heard that information, and we're going to take it into consideration.
Thank you.
But if they're asking questions of the petitioner, that's valid. The time that it takes to ask those questions, I think we have to allow that time.
There's been different cases where we've had review questions that come up rather than, there's sometimes where they do direct answer, depending on the size of the project or whatnot. So if there's a direct question to the petitioner, we've had them respond in some cases, or they direct it to the board, and then the developer has the opportunity to respond, to those inquiries. For some larger cases, I've seen also occur where you have a series of residents or concerned individuals come up that express questions, and then after a few of those, then the developer responds. Or in a case, if they do have an attorney, there could be direct questioning back and forth in that case, where it's more you're proceeding over the court from that standpoint. But you let that judicial process kind of play out.
Thank you.
All right, we've touched on this before, that aesthetics, your personal feeling about how something looks, is relevant. It is typically not a basis for, the sole basis for deciding whether or not to grant a request for particular zoning relief. That's different sometimes if you have standards for exterior design. So if you have specific standards in the code that say the determination of the exterior appearance of a facility, and then you set forth the standards that you expect it to meet relative to adjoining property, relative to the quality of the materials, whatever that is, those can be relied on for decision-making if they have been set out in some kind of objective fashion. If it's more, I don't like the way this thing looks, that is a weaker basis for making a particular determination or recommendation. Even though you can still say that, I don't like the way this thing looks. It still sends a message to the developer that, look, it's not where we want it to be. It's just not the only basis that we should rely on to make a decision. So this just walks us through that standards are important. So here are standards that did not meet, at least the test applied in court, when a municipality tried to rely on the standards they created. The Exterior Review Committee in one of these cases was allowed to consider excessive similarity, dissimilarity, or inappropriateness in exterior design and appearance of property. Inappropriateness in exterior design, that's not a standard. It's too subjective. Same thing with committee rejected plans for a single-family home is incompatible with neighboring development. The terms harmonious conformance, inappropriate materials, durable quality, good proportions, exposed accessories were not considered to be reasonably objective criteria. I think monotony of design probably should be, well, it probably should be a criteria. If you were looking for something that doesn't look like row houses for the entire street, That does seem like a reasonable criteria to me. The court did not agree.
Well, that was back in '86 though, right? So
Yeah.
it's time for another review.
Traffic, we already went through this as well. Everything generates traffic. Our Supreme Court, the Illinois Supreme Court, has concluded while we've recognized traffic as a factor, it is not in itself entitled to too much weight since it is a problem in all but the most sheltered neighborhoods and is constantly getting worse. I don't know if you've ever had this happen before, that the ZPA made a recommendation in regard to a zoning issue, whether or not somebody's property should or should not be rezoned, and impose conditions on the rezoning. Imposing conditions on a rezoning is inconsistent with the law related to zoning. A zoning category of a property is supposed to be based on meeting the standards in our code. To impose conditions in order to be entitled to the zoning that your property should be is inconsistent with those standards. It should just be subject to those standards. But I don't know if that's ever an issue that the ZPA has.
I was just looking at Frank,
I've never
seen that here.
my 20, whatever years, no.
Yeah, that's, just from a planning perspective, that's kind of planning 101. You know, from a, you know, if you rezone a property, it's either zone that designation or it's not. There's no condition that you would put on it. You can, we'll zone it this, but then you can't do X, Y, and Z with it.
Yeah, you can't do, these uses are not allowed on your property if we're gonna rezone it here. That's not consistent with zoning principles.
Correct.
Spot zoning, same thing. When we talk about planning and zoning, fundamentally, it is intended to avoid incompatible uses next to one another and to create a set of zoning districts that allows for transitional uses among and between those zones. Spot zoning is that tower I showed you. It just gets plunked down in the middle of a neighborhood it doesn't belong in and is completely inconsistent with the other uses around it. Prohibiting uses, we can prohibit uses in zones. We can't really prohibit lawful uses across the entire village, except in extraordinary circumstances. So obviously, we have varying zones in the village that allow for certain uses and don't allow for others. But to prohibit lawful uses altogether across the entire village, that's a heavy lift. To say, even though you're a property owner and you're proposing a lawful use, we have no property in the village where this would work. Now, that's possible without prohibiting the use. We can effectively prohibit a use by saying you have to have this number of acres, or you can't be next to this particular kind of use, or right, whatever it is. Right, but to prohibit the use itself is impermissible. And then, this is the last thing I'm just referencing, you have a portion of your code that relates to this particular zoning tool, as a planned unit development, which allows for a combination of really allows for a combination of the relief you grant by variation, the relief you grant by conditional use, the relief that you grant under the subdivision code, or permissions that you grant under the subdivision code, in one tool, a plan development that provides for all aspects to be integrated into a single development plan. It is still subject to the subdivision code, is considered to be a subdivision of plan development. And it relates to, your code provides that no non-single family development, either on a lot with an area over 87,120 feet or greater, or located within the B1 or B3R districts, is permitted unless it is approved as a plan development. And the plan development has, I showed you the standards for variations, for conditional uses, for text amendments. The plan development has a significant number of goals, objectives, and standards that must be met in order for the plan development to be recommended and approved. And I'm not going to go through those. Any questions?
Well, that was helpful. And just to kind of give you the back channel to this, is that one of the things that we agreed to when we went through the new UDO is that we wanted to, as a committee, adopt best practices within the document, but also as a committee, try to improve individually. So this is part of that commitment. And one of the questions I had for you is that since this, you know this far better than I do, there's communities in and around our area that are doing it well, and there are those that are pointed to that are perhaps not doing it well, but I'm wondering out loud if you can point to various communities that say, that committee over there, they do it particularly well, you may want to observe them, or check those folks out.
Oh, the Planning and Zoning Commission?
Sure.
No, I don't really, I don't know that I have a model.
Yeah.
This group is a good group and is thoughtful and careful in your proceedings. Your UDO is a good document.
It is.
That regulates development well and allows for plenty of flexibility with plan unit development, so, no, I mean,
One of the things we were trying to do, but things change, right? So we were trying to get together with the Crystal Lake folks, because I knew a couple of the folks over there, but the person that was in Brian's role left. So we were moving down a path to try to at least have some coordination with education. We didn't get there yet, but that was something that we were exploring with them and with Algonquin. So that's not off the table as far as I'm concerned. I still think we should consider that.
Yeah, and this is still something, we were discussing that with the village administrator today, that there's potentially ability to have those kind of discussions with the other communities.
We learn from each other.
And, yeah, training, joint training opportunities or whatnot, just for discussion to make sure what are the challenges that other communities facing, or the type of challenges they had at a zoning board, that you can learn from it as well with, you know, if Crystal Lake or Algonquin may have more controversial projects because they're larger and there's more volume that they see, there may be ability to have those discussions with those board members to, you know, learn from them as well. And not just, you know, with those nearby communities, but there also is, through the American Planning Association, the Illinois chapter does offer training to board members or commission members as well, on a regular basis. The Planning Association does have a annual conference from the state that I'm a part of, that I think I've thrown out to the board in the past. You know, if that's something that any member's interested in, they do offer plan commission training opportunities there. So if that's something that any board member is ever interested in, the next time that conference comes up, I'm happy to have the village pay for that cost to attend that. I think the next conference is somewhere in the Chicagoland area, so it's more local. I think it's actually downtown this year. So if that's something that any individual on the board is interested in participating in, certainly is an opportunity that's there, that the village would pay for that cost to attend.
Can I recommend that we just formally put that in as our to-do list, and who wants to take advantage of it can, and so, just so they know,
Yeah.
you know, months in advance for their own plan?
Yeah, the conference typically is August, September time period of the year, so it's, again, that training's offered all the time at that conference, but they also occasionally do offer it outside of the conference for specific, if another community is doing something, you know, obviously we have our attorney here that can provide training, but if there's a desire to get, you know, more knowledge of it, of a day-long course versus an hour presentation, you certainly have that ability, and the village is very willing to pay for the cost to attend that.
All right, well, before we conclude here, I just want to say thank you to Brian for putting this together, and to Mr. Euler, thank you very much. I know you got stuff going on, for sure. So thank you. I found it very helpful, guys, personally. And so this is our commitment to each other, that we were trying to collectively move forward together and get stronger together. So, because a couple of these petitions you see coming down the path, they're going to get complicated. There'll be a lot of people here.
Meyer, come on.
Yeah.
Yeah, nothing will be.
I had
Nothing's Meyer.
one last comment.
Yeah.
So this last slide was really intended to address the idea, we face different housing pressures and development pressures over time. If we look back, I don't remember when the legislation was enacted, but there was legislation enacted in Illinois that we still are subject to regarding low-income housing, that a certain percentage of our housing has to be dedicated to low-income housing. The reason for that, one of the principal reasons for that, is the pressure that has existed over time for a certain segment of the population to have access to affordable housing. We are in a period right now where there is pressure on the housing market to create affordable housing for individuals that need it, young couples, families, that are struggling to identify affordable housing, whether that's single-family housing or multi-unit residential housing. But that pressure continues to exist at times, and at different times, it is more intense than others. Right now, I think we probably are in a period where that pressure is particularly intense to develop enough affordable housing for the population. So the idea that, would everybody like affordable single-family housing? Of course we would. Affordable single-family housing is ideal, but it's not necessarily realistic.
Thank you.
Okay?
All right, so I'm not sure how we're going to do this, everyone, but we didn't adjourn the other meeting, so just to be formal about it, I'm not sure if this training piece is going to show up on there.
Yeah,
It
yeah.
showed in the schedule as part of this meeting.
So
Yes.
we'll probably just keep it, so then the chair is going to entertain a motion to adjourn.
So moved.
Meeting adjourned. Thank you.
You're so good at that.